Welcome to Voices of Tech and Litigation with your host, Ray Beken. This podcast will broaden your knowledge in the use of technology in business and our everyday world. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, chorusconsulting.net. Now here's the host of Voices of Tech and Litigation, Ray Beken.
Hello, thanks for tuning in. Hey, Doug. Hope everything's good.
Hey, Ray.
Good. Hey, everybody. I've got Doug Austin with me here today. Doug and I worked together at Cloud9 for almost a decade. Feels like a lifetime ago, but we worked together a long time. He has 30 plus years experience in eDiscovery and computer forensics and case law and a bunch of stuff. I don't want to steal his thunder, but he's also has 13 plus years of daily blogging. So with that intro, 13 years of daily blogging is a lot of
committed
blogging.
Or I ought to be that's what I tell everybody. So there you go.
Yeah. Well, how did you become a daily blogger, and how do you decide what to cover every single day?
You mentioned I worked at Cloud9, and actually when I started at Cloud9, on my very first day, the CEO and co-founder, Brad Jenkins, took me to lunch. And first he asked me if I'd done any marketing. And I said, yeah, I've written some content. I've done this, I've done that. And he said, great, you're our director of marketing. And then he asked if, he said, and by the way, we have a blog all designed, ready to go. It just needs content. And I said, great, what's it called? He said, eDiscovery Daily. And I said, that's a terrible name for a blog, because if it's eDiscovery Daily, it's got to be daily. But I thought about it and thought, well, we'll give it a try for a while and see where it goes. And I didn't know how long, maybe a couple of years or so of trying to do a daily blog. And before you know it, I'd done it for nearly 10 years at Cloud9. And now I've done it for nearly 4 years at my own blog, eDiscovery Today, where I've just when I left Cloud9, started my own blog and have been doing now not just daily posts, but multiple posts most days. So I am very committed, or ought to be, for sure. As for what do I decide to cover, it's a variety of factors. One of the things I do is I try to cover several cases a month, at least 6 case law posts. I do have a number of partners that are educational partners. So part of the deal, of course, is I, coordinate with them and cover their thought leadership and their educational content and what have you. So that provides a lot of resources as well. And then a lot of the other things are just really things that I think are interesting to the readers. And of course, it's eDiscovery Daily, so eDiscovery is first and foremost, but I really try to, because eDiscovery ties into so many other areas. It ties into cybersecurity, and it ties into data privacy, and it ties into information governance, and it certainly ties into AI, which we'll talk about here in a bit. And you can't really avoid the AI topic any these days. So, I really try to continue to bring content to the readers, either that are written by me or crowdsourced by people out there providing amazing content, and use that as a way of just trying to continue to provide good content that the readers will enjoy.
Yeah, so it probably takes a lot of research, a lot of reading, and a lot of digging into things going on, which leads to you probably see a lot of trends out there, and you probably can foresee some things going on and that sort of thing, just with the sheer amount of research that you do. What are some of the eDiscovery trends or challenges that you see on the horizon?
Sure. A couple of trends that I think we've seen over the past handful of years. One is, I think, this discussion about the focus on the move to the left of the EDRM, where there's a greater focus on on things like identification and preservation in place and indexing in place, and things of that nature. And as a kind of an adjunct to that, integration with the cloud. So many of our data sources today are in the cloud. Even what traditionally was on premise, like Office and Outlook and and what have you, are now available in the cloud, which is making it easier for eDiscovery solutions to integrate with those data sources and those platforms. So I'm seeing a lot more direct integration with those platforms, which has really started to move the EDRM to the left and get more focus on doing the early case assessment, where you're determining before collecting potentially responsive ESI, and then you're moving it along instead of moving along entire custodian stores. So I think that's one of the big trends that we're seeing that I think is continuing to pick up steam as we go. Another trend that I've seen is, and last year we did we took over, there was a marketing person who had been doing an Internet Minute infographic, which I thought was great for several years. She suddenly stopped doing it. So last year we decided to pick it up and provide stats on different things that happen in the internet every minute. And we took kind of an eDiscovery focus. So we're seeing, lots more different types of data out there that's discoverable. Things, of course, certainly mobile device data like text messages and other data off the mobile devices. That could be notes, that could be images, what have you. Collaboration and chat applications like Slack and Teams, and I even covered a case last year involving spoliation of Basecamp data. So there's just more sources than you can really count, and I think that's been a real key. And then I think one of the things that's gotten a bit of discussion in the industry, and people taking different sides to the issue, is what we call the modern attachments issue. Where the files used to be embedded within the email, and now, because a lot of these are cloud sources, people, understandably so, link to that file instead of sending it around everywhere, which is great from an information governance standpoint, but it causes all sorts of nightmares from an eDiscovery standpoint, because the linking to that file may not be as straightforward as it could be. That file may not even be there, or it may be a different version than at the time it was sent. And so I think there's a lot of people who are trying to decide, should these hyperlinked files be treated as modern attachments or not? And I think that's one of the things we're continuing to see development in. And part of the thing I think will ultimately happen is where the platforms, which are the sources of these of the data, of the hyperlinked files and what have you, are continuing to add capabilities, because I think they really need to, where eventually I think it will be a straightforward process to collect those files and treat them as if they were attachments for those who need to do so. And of course, finally, the elephant in the room is generative AI, but I know we'll talk about that a little bit down the road. So I'll just kind of save that one, because that one's a like I say, a topic you can't avoid.
Yeah, to go with the linked documents, I'm seeing some improvements in the versioning and the link staying active even if it's changed, and linking back to the correct version and stuff like that. So both
M365 and Google have made progress in those areas. I think some of the people who are in the trenches are still saying there's some issues with it, but I think we're getting there. So
okay, cool. Well, again, we will get to AI, but I also want to ask you about case law. You cover a lot of case law, and you read a lot of cases. What are some trends in case law that you're seeing related to eDiscovery?
Sure. as I mentioned, try to cover at least 6 cases a month, and probably read 2 to 3 times that, if not more, trying to decide cases to cover. We cover those cases on the EDRM monthly webinar with Mary Mack and Tom O'Connor and Judge Andrew Beck, and all of them are great in terms of the insights they provide to those cases. From a standpoint of trends, one of the things I'm seeing more of is I'm seeing more cases that involve sanctions for spoliation of video evidence. We're seeing, and actually in one instance, I was just reading a case today that Kelly Twigger covered that involved basically creating fraudulent evidence where they took 2 videos and kind of shoved them together and tried to make them as if they were seamless. And it became apparent when you reviewed the video that they were saved using a YouTube kind of editor type of program. So, one of the things I think we're seeing is a lot more video evidence, and organizations aren't prepared, which is why we're seeing spoliation and sanctions as a result of that. So that's certainly one thing we're seeing. Another thing we're seeing is a lot of disputes over privilege, over whether privilege is appropriate. Should there be in-camera reviews by judges? Sometimes judges will say, it's not. I'm not going to do the in-camera review, or I'll use a special master to do it if it's a large enough case or what have you, because there's a lot of disputes over what is and what isn't privileged. And there's also disputes on over the information in a privilege log. We're seeing a lot of different issues there. Is not enough information, or one side wants to use a categorical log, which is at a higher level. The other side doesn't want them to do that. So I think we've seen kind of a rise in those types of cases. Certainly one of the things we're seeing as we continue to get more and more data is proportionality disputes, some of which have involved a case where a party basically gets requests for production and then responds with a boilerplate objection. And the 2015 rules outlaw, basically, they'll say overbroad, unduly burdensome, and so on and so forth, without really getting to the specificity of the objection. And we're seeing courts more and more reject those boilerplate objections and say that objections are waived as a result of using them. And we're also seeing, though, some cases where they're disputing over the proportionality, and it could be over search terms, it could be over custodian, which custodians to include, variety of factors there. So I think that's one of the things, as there continues to be more and more data types out there, proportionality disputes will increase. And then finally, like say, I mentioned modern attachments. We're starting to see some cases involving modern attachments. We saw, I think, 3 last year, if I remember correctly, and we've seen, there's been a couple of others that are notable in previous years, and we've seen some that favored you treating them as modern attachments and some that didn't. Most of that has come down to ESI protocols, which was the next thing I'll get to, what's been discussed and decided in the ESI protocol. So certainly before agreeing to an ESI protocol, you need to know your position on modern attachments and what, if you are a producing party, what you can and can't do with regards to those hyperlinked files. But ESI protocols are another thing we're seeing disputes over, where because of the increased rigidity of Rule 37E and the intent to deprive standard, a lot of parties are starting to work towards getting a court order, which is what they typically do with an ESI protocol, and then failing to fulfill a part of the ESI protocol, they're trying to go after 37B2 sanctions. So another different way to go about it. So the use of ESI protocols is certainly increased, and I think also the scrutiny about best practices in using them has as well. Not everybody's in favor of using them in every case, and I think that's something that you need to think about as well. So those are some of the things I've seen in case law. And, of course, we always have, all types of sanction cases. We're seeing a lot more mobile device cases too. That's the other one I missed that involved. I just covered one this morning on spoliation of text messages, where the defendant just arbitrarily decided which messages they were keeping and which ones they were deleting. And that the court said, well, that's intent to deprive, because you were supposed to preserve them. You had a litigation hold notice. So, those are the types of things that we're seeing in case law today.
Yeah. Well, one of the things you talked about in that case law was AI. So why don't we talk about the elephant? AI is like the talk of the world right now. So why don't we talk specifically about impact in eDiscovery and our world that we're in every day?
Sure. So certainly from an eDiscovery standpoint, I'll start there. We're seeing so many platforms. It seems like every platform out there has either already added some generative AI capabilities, or they're trying to add some generative AI capabilities, and they're trying to do it as quickly as possible. Certainly some, I think, have been a little bit more cautious, and they've established kind of their guidelines and their philosophy and their ethics associated with the use of generative AI. One of the things that I think a lot of them have done is they've been quick to create the capabilities, but they've had a lengthy beta in terms of clients using them. So they've, I think, tried to learn kind of from these processes, and we're also starting to see a couple of case studies that have come out where people have used the generative AI tools and what they found that's been good and bad and so forth. And like anything else, it's a tool. So you're going to have to develop, just as we did with TAR, you're going to have to develop workflows and best practices in using them, and have a standard for verifying and quality control on the output and the results coming from generative AI. So from an eDiscovery standpoint, I think a lot's going to happen over these next few years. Every year I do a state of the industry report, and for the first time this year I asked 2 generative AI questions, and one of them was the percentage of people who thought that generative AI would have a transformative, what effect it would have this year. And almost a quarter thought it would have a transformative effect this year, and about 3/4 thought it would at least impact changing workflows and what have you. So clearly people see it having a major impact in eDiscovery, and I agree with that. In terms of kind of the legal world, certainly one of the things we've seen is a lot of instances with lawyers filing case filings with fake case citations that were generated by ChatGPT. And of course, everybody's talked about the Avianca case and the lawyers there who did submitted a filing with fake case citations. And so I think that's one of the things that people are starting to learn is there's got to be, again, you've got to learn to treat it as a tool, not just take the output it gives you and run with it. And the poor attorney on the Avianca case, they were both, I think both attorneys involved were fined $5,000 each. And I swear, I think I've heard that case mentioned 5,000 times in webinars and everything else. That's a way bigger punishment than the $5,000 he was fined. So I definitely think we're seeing that. We're seeing some courts react by having some certification standards. Did you use generative AI and can certify that you checked you checked the work, if you will. But other courts are just saying there's existing rules that deal with the ethics of your work product, and we're relying on those. So which I think is the better way to go. From a legal standpoint as well, I mean, we're seeing lots of use cases. We're seeing it in contracts. We're seeing it, we're seeing it all over. And one of the things I did last year is I actually put together an infographic on 12 legal use cases for generative AI. And I came up with a few of them, and then I decided, well, I'll ask ChatGPT what use cases can it identify, and sure enough, it came up with 2 or 3 good ones. One of which was investing in litigation, because there's companies out there that invest in litigation outcomes, and they use the analytics to help kind of make determinations on those investments, and now they're using the generative AI to help with that. And that was not a use case I would have ever thought of. So it just really is interesting how we're seeing a lot of different potential use cases arising from the legal, in terms of the legal industry. And when I put out that infographic and threw it out there on LinkedIn, a bunch of people said, well, what about this one? You forgot this one. I said, I was limiting to 12, but yeah, these are all legit too. So yeah, from a business standpoint, I think some of the considerations have got to be, all of those. And then of course, data privacy, what data is it using? Is that data being managed properly? Is it being secure? Are we training the model with private data that could be regurgitated? Because we've seen a couple of instances of that. And then of course, copyright of the content that's being used, which, OpenAI has several copyright cases filed against it, including the huge one from New York Times. So far, early case results in a couple of instances, it seems as though courts are leaning towards OpenAI's position and other companies' position that it's fair use of the of the content. But I think there's a long way to go there, and certainly the consideration of, are you using something that is copyrighted has got to be at the forefront of a lot of organizations thinking when it comes to using generative AI models.
Yeah, seems like muddy water.
Really. Oh yeah, absolutely. And and hey, I mean, it's kind of one of those things. It's still a pretty new technology, and probably not surprising that it's going to take a while to really start formalizing and getting to a point where it can be used here are the capabilities, and so forth.
Yeah. Well, how's it affecting the blogger world, right? Yeah, I guess you can have people throwing information into an AI tool, and out comes a blog.
Well, yeah, I mean, my initial reaction was, be afraid, be very afraid, because, I was like, holy crap. I mean, the content quality, I've been using, excuse me, I've been using ChatGPT-4 for over a year now, and the quality of the content is pretty impressive. But one of the things, of course, that I've seen, there was an instance last year where there were a couple of people who actually published an article, a 2-part article that was published on one of our major legal tech publications, and it turned out they made the mistake that we've seen some attorneys make. They linked to, or they referenced publications from some leading experts that didn't exist, that were bogus. And it was clear when you started dissecting the article, it was written by ChatGPT, and that legal publication got notified by those experts who found out their bogus things were being quoted about what they'd done, and they took down those articles. So, I think one of the things that I kind of advocate is, it's great to use as a tool. It's great to use to get ideas. If I want to say, give me best practices, give me several best practices for this, or challenges for that, or what have you, I'll get a list and I'll go, oh, okay, yeah, I hadn't, that one hadn't crossed my mind, but that one makes sense, and I'll use it and work with it. And sometimes even a sentence here or there, I generally don't like the way it writes. It tends to be over formalized, and it doesn't write the way I would write. So I tend to take it from an idea standpoint of the idea it's trying to bring across, but tend to use my own words. But I think the biggest consideration from a standpoint of blogging, if you really want to establish yourself, is by definition, these large language models, they can't provide thought leadership because they're trained on what everybody else is saying. Right. So if you really want to provide thought leadership out there, you need to you really need to draw on your own experiences, and the projects you worked on, the things you've done, people you've talked to, and so forth, because you're not going to really stand out if you're going to rely on a tool like a ChatGPT for your content. Yes, it might sound good, but it's really not going to be a differentiator. So that's one of the things I'm mindful of is thought leadership is, I think, how a lot of folks in our industry really try to differentiate themselves. And I think we have quite a number of thought leaders in our industry. And I think they need to, it can be a great idea for some information that ties into what you were talking about, but you got to let that thought leadership emerge.
No, agreed. Well, those are some great thoughts. How's that? Yeah, Doug, I'm going to end there, but I really appreciate your time. Everybody, this has been Doug Austin with eDiscovery today, and I am Ray Beken with Chorus Consulting. Hope you all enjoyed it. Any closing remarks before the camera goes off?
Well, gosh, Ray, you mentioned we worked all those years. We not just worked all those years together, but we were side by side in offices for.
That's right.
For all those years. Went to lunch a bunch of times. Great to see you. Thanks for inviting me. And look, hopefully we can catch up in person soon.
Sounds good. I appreciate your time.
All right.
You've been tuning into Voices of Tech and Litigation with your host, Ray Beken. You can find this show on all the major platforms, including YouTube, LinkedIn, Facebook, Apple Podcasts, Spotify, and on our website, chorusconsulting.net. Thank you for your positive reviews, comments, questions, and for sharing this show with others.